Even if the employer is not a member of a federation signing a collective agreement, and even if the employees are not unionized or affiliated to any union, the company must apply a collective agreement. Because of this kind of compulsory nature of the collective agreements, they provide for minimal basic protection.
You're listening to the Global Workforce Podcast with me, George Britton. Each week, we interview an industry expert to dive deeper into the world of managing a global workforce and discuss the big strategic challenges that you're going to encounter along the way. This episode is brought to you by Omnipresent, the global employment platform that allows you to employ anyone, anywhere without having to set up an entity. Designed, built, and supported by global employment experts, Omnipresent takes care of your international employees and contractors, so you don't have to worry about payroll, HR, or compliance issues, making it easier, faster, and safer to expand internationally. I'm delighted to be joined today by an expert on both national and international employment law. Juan Bonilla's expertise spans contract terminations, employee compensation schemes, particularly share-based compensation, and the labour implications of corporate transactions. As well as being a partner at Cuatrecasas, Juan is a member of the Employment and Industrial Relations Committee of the International Bar Association, the IBA, and a former director of the Global Equity Organization, GEO, where he was awarded the GEO Pioneer Award for his outstanding contributions. Juan frequently speaks on labor law and compensation schemes at international conferences and postgraduate courses, and he's published extensively in both local and international publications. Juan, welcome to the Global Workforce Podcast.
Well, thank you very much, George. I mean, it is a pleasure and an honor for me to be able to participate on this podcast and also to represent Spain. So I'm really happy to be here with you. Thanks again.
Amazing. I'm really excited. So let me jump straight in, Juan. Spain has always been one of our most popular markets to employ people in. In fact, with some recent opportunities we've just brought in, it's now gone from our fourth most popular country to our third. Can you give a bit of a sense for those people that haven't employed in Spain before? What makes it so popular? What are the kind of expansion potential for companies, and how does it kind of compare to other European countries as well?
Mhm. Well, thanks, George, for the question. I mean, Spain has always and traditionally kind of been a relatively kind of good country for global companies. I mean, even before COVID, I mean, before the COVID world back in 2020, I mean, Spain was a very reliable country in terms of having shared service centers. So, global companies having excellent centers or, customer centers whereby you could hire people from different nationalities to come to Spain. And of course, this trend has been increased relatively in the post-COVID world because of the kind of interest of some employees in order to work from home and to work remotely. So, I mean, Spain, and this is definitely not a legal issue, but it comes more with kind of with the culture. I mean, it is a relatively well-viewed country for those who are doing work from home. I mean, of course, we have the weather. I mean, of course, we have kind of a quality of life, but also we have kind of a relatively good balance in terms of cost, and also the quality of life we were saying. And again, this was kind of the reason or the rationale behind having, significant shared service centers in Spain. And that's definitely one of the rationales now for, a number of employees who are working from home, who prefer not to work in, big city, having, critical and brutal winters, and they prefer just to do exactly the same kind of work they can do from home, and they can, do it from a more kind of, good weather areas. And Spain is definitely one of those. So, I mean, I would say that if you see the past pre-COVID world and also the post-COVID world, I would say that the good point in Spain is it provides a good balance in between cost for the companies and also quality of life for the employees.
Yeah, that's really interesting. It's really interesting you mentioned the shared service center piece, because you now remind me that in a previous company, we were deciding on where we set up an engineering hub. We were based out of London, but we wanted to hire, to employ somewhere else. And we were in between Spain and also a couple of Eastern European countries we looked at, but actually the CTO in the end decided on Spain and Madrid in particular, which kind of surprised me a bit. But like you say, it's that balance between culture, really good talent pools in the country, but then also like the cost balancing out, right?
Mhm. Yeah, absolutely. And it's definitely, I mean, we've improved a lot in terms of language skills as well. But it's also kind of easier to, tell anyone from 25 different countries in Europe to have a hub in Spain than, with all due respect, of course, than in other countries where, again, winters might be brutal. I mean, it will be, as dark. I mean, you can see the clear skies, here I'm in my office today. So, it helps and it's been kind of quite profitable for, companies in the past. So again, that's one of the reasons like there's so many people just working remotely, not only from mainland Spain, but also from the islands, because we have the Canary Islands as well, and we have the Balearic Islands, and it really attracts kind of people from all over the world, and particularly from over Europe to work. Even if, in the Canary Islands, there's some people working, let's say 6 months a year in the Canary Islands and then 6 months a year in the Nordics. So that's also kind of a relatively popular kind of scheme of arrangement for the contracts of employment there.
Yeah, absolutely. Actually, one of my team members that I see every day is based in the Canary Islands, and I'm very jealous when I see her every day in Gran Canaria. Also,
Yeah, we're all very jealous, even for those of us who want to live in Madrid or in mainland Spain. Yeah.
but it's also what it's interesting. It's really easy for her to commute back to mainland Spain because they have subsidized flights. So that's an interesting one. But also, I've seemed to have been in Barcelona quite a few times in the last couple of years, and every time I go there, I was there about a month ago for an event, and so many tech companies there right now, so many hubs, so many talent acquisition teams. It's really kind of buzzing over there right now.
And then the third country, which is kind of becoming very popular both for shared service centers and for home office work, besides kind of Barcelona and the Canary Islands, which is Malaga in the Costa del Sol in Andalusia. Malaga has increased a lot, and I've got a lot of clients who had shared service centers, centers of excellence, and they have kind of really an international population there as well. So it's another place to see.
Yeah, makes total sense. Cool. So one thing I wanted to pick your brains on was, so you've worked on both the national and international level. So you must see a lot of companies that are employing in Spain for the first time. What are some of the key misconceptions that they might have when they're doing that for the first time?
Mhm. Well, that's a very good question. I mean, George. I mean, the first misconception, which is not even a misconception, because for me, particularly when U.S. companies they plan to launch their business in Spain, they know generally that Spain, as many countries within the European Union, or as all countries within the European Union, Spain is not an at will employment country, which means that once you've hired an employee in Spain, if you want to terminate the employment, you would usually have to pay severance. I know that's kind of a very well-known concept all over the European Union and even the UK. But as you know, in the States, they have the concept of employment at will, which, every day the employment is kind of continued. And you can terminate at the will of each of the parties at any time without paying any compensation generally or usually. But here we have a concept of statutory severance, which is very well developed. So if you want to terminate unemployment in Spain, once you've hired and once you've taken the decision to hire someone, you will need to pay severance. I mean, it might be higher if you do operate the termination or implement the termination by means of a termination without cost, and that will equal to a severance of 33 days of salary per year of service. You can do a genuine redundancy as another option, and that will reduce the cost of severance to 20 days of salary per year of service. But at any extent, we are talking into the fact that you would have to, pay some sort of termination payment to the employees, unless, of course, the termination take place by means of what we call a gross misconduct. So that's kind of the first misconception, which is, again, not typically a misconception because everyone understands that you would have to pay something if you want to terminate unemployment in Europe generally. But in Spain, the cost is much higher, at least if you compare that to the cost of the UK, which we're talking about, half a week, or a week and a half per year of service. Here, we're talking about more than a month of salary per year of service, 33 days of salary per year of service on a general basis. And that's kind of sort of the magic circle, or sort of the magic figure that every employee has in mind. And if you want to get a settlement or a compromise agreement, it is relatively difficult to get it below kind of this sort of magic figure or magic value of 33 days of salary per year of service. So that's probably kind of, the first point I wanted to mention. Then, in terms of more kind of misconceptions, there's one typical misconception, which is the treatment or the requirements to have post-termination non-compete in Spain. So in other countries, you can have a post-termination non-compete, which will prevent the employee from working for a competitor or from poaching customers or clients or employees from the company. And in some countries, you don't have to pay any consideration for that. So you can have a post-termination restrictive covenant, and then it's inherent, so to speak, to the contract of employment. In Spain, there is a legal requirement to pay separate consideration or compensation in consideration for the restrictions. So if you want to hire an employee and you want to say, okay, you have access to very confidential information, we don't want you to work for a competitor, let's say, within 6 months following the termination date of employment, no matter how the termination takes place, then the company would have to pay something to the employee, again, in consideration for the restrictions. How much is it? It might be 20% of the salary for these 6 months. It might be a 35%. It might be a 50% of the salary. That is subject to the negotiation and, of course, to the policy that every company wants to put in place. But there is a need to pay a specific consideration, which is not simply because I pay the base salary to the employee, then you would have to enforce, you would have the ability as a company to enforce the post-termination non-compete. So that's kind of one of the misconceptions that, I've seen in my past practice. Then there is also another one, which is the concept of discretion. And that applies particularly to benefit plans or compensation and benefits schemes. So for instance, you have a bonus plan, you have an annual bonus plan, and then the company can say, okay, well, these are the targets, these are the metrics to be considered when making the payment of the bonus, but I retain the full discretion as to whether I would eventually pay the amount or not. So this concept of discretion is not kind of well seen or well interpreted particularly by not only by the Spanish legislation, but also by the Spanish case law, because the Spanish case law says is that you have discretion on the targets or on the metrics. But once you've set out the targets and the metrics, if the employee has done right, and if the company has met the metric, has reached the levels that you identified as a company at the very beginning, then you cannot discretionarily eliminate the benefit because it's already vested. It is already accrued. And the company, using the discretionary argument or the discretionary piece of the bonus plan, cannot exercise this discretion so as to eliminate the payment of the bonus, which actually means that it is much more important to decide the targets at the beginning of the year, to communicate properly the targets at the end of the year, to use the discretion when you determine the targets, because once you've set out the targets, you won't be able to take the decision not to pay the bonus if the targets have actually been made. So that's kind of a typical misconception that we see, particularly with US companies, but also with companies from other countries as well. And there's a final point on my side, which is, and that again, that applies generally to Europe, but specifically to Spain, we have works councils, we have employee representatives. So even if for companies that are employing 10 or more employees, you might have employee delegates or some form of works council member or employee representation member. And if you have a works council in Spain, which is also kind of quite typical for companies, once they've grown relatively to a certain level, to have works councils representing the employees, you would have to comply with some sort of information and consultation rights with them. Particularly, Spain is a quite unionized country, particularly in certain sectors, and it is not atypical to have work councils in the workplace. It's something that companies would have to manage and navigate, but it's again, ordinary course of business for us.
Yeah, that makes a lot of sense. It's really interesting you mentioned the point about discretion, because I think in every single, so as someone who's been a sales leader for the last 10 years, I think every single compensation plan I've ever written or ever shared has always had a discretionary clause in it, right? But it's really interesting to say that doesn't really hold up in Spain. That's super interesting.
It is. And we've done kind of into, high profile litigation cases, particularly based on this specific piece, particularly dealing with employees who have worked for the full year, from the 1st of January until the 31st of December. They've decided to move out and go to another company and to resign from the company, let's say in March of the following year. And then the company said, okay, now I'm using my discretion and I'm not paying you the bonus because you are a bad leaver. And we've significantly litigated that. So there's an issue that has been into a number of contentious situations. Some of them we've been successful, some of them we haven't been as successful. But of course, the general rule is that the judge will say you can implement the discretion. You can use your discretion when you set up the targets, but if targets have been met, then you would end up you eventually have to pay for the bonus, or um,
Yeah.
on the benefit of the employees.
Yeah. Yeah. Well, fortunately, all of my sales teams always hit targets, so it's never been an issue for me.
It's
Um, cool. So,
perfect.
look, bearing some of these things in mind, kind of, three of those things I think you talk about there are kind of related to terminations, and then one about works councils. What would be your kind of key pieces of advice to people who are starting out to employ in Spain for the first time?
Well, first of all, is to be trained and educated, to be educated a little bit about, the pros and cons of employing. That applies to Spain, and that applies to any other country where, a global company would like to, start business. Um, I think these are kind of essentially the key points. Be aware that when you terminate employment, you will have to pay some sort of severance in most of the cases. Be aware that, if the company grows up significantly, you might have some sort of employer representation, which again, it is pretty typical, and it's a manageable process that can be easily be navigated. And then number three, be aware that not every compensation system that you use worldwide will be applicable to the same level of extent in Spain. So this will be kind of the three kind of major points. Then there is also the issue of particularly how to implement when you decide to start up your business in Spain. And which is, where are the options for, for a company which has no presence in Spain, how you can employ an individual, right? And, not on the more on the formal, on the sort of on the material employment law standpoint, but also more on the formal, how you can have a contract of employment, how you can sign a contract of employment, and how you can register the employee before the employment authorities in Spain. So essentially, there are a number of ways that a company wanted to start out as a Spanish employer that they can analyze and they can review. Of course, that is the traditional option to hire independent contractors in Spain. That has always kind of been the case. It has the advantage that you don't have to register an employing entity, but it has the disadvantage that it is very, very possible that the independent contractor at the time of the termination might issue a misclassification case, which is simply the independent contractor will be claiming that the independent contractor should have been regarded as an employee and should be classified as an employee, with all kind of the liabilities that will be associated with this declaration of misclassification. So it's an option that, it can be workable and a useful tool, but for a relatively short period of time. If you have a contractor working for 20 years, then you might have much more difficulties when, having to, argue or defend that this doesn't qualify as a contractor per se. Then, of course, there is the possibility to set up a subsidiary in Spain, but we all know that this creates and takes time and money, right? So you have to set up a company, you have to do the secretarial work, have to appoint directors, you have to have some sort of separate accountability, you have to pay taxes, corporate taxes in Spain. You need to run together with a payroll company. So there are a number of costs associated with just simply kind of the running of a subco, a subsidiary company in Spain. Then it is also possible to register a foreign company as an employing entity in Spain. There is a specific process for that, which requires a power of attorney and a designation of a tax representative in Spain. It is not a well-known model, but it is becoming kind of much more popular on practical terms. And then you have the option of the employer of record, which is, a very, very sort of convenient way to employ individuals, particularly when the company is on the first stage of the launching or starting out process in Spain. And as an employer of record, then at least you guarantee that compliance in terms of salaries and payment of social security contributions and also payment of income tax withholdings, is guaranteed to the respective governments and employment and tax authorities. So at least in terms of compliance and in terms of risk assessment, particularly if you compare that option to the independent contractor, because the independent contractor is paying its own or his own or their own social security contributions and income tax withholdings. And if there is a misclassification case, then the burden of the withholdings reverts back to the company. And there might be kind of a significant liability, which at least with the employer of record doing the appropriate tax withholdings and social security contribution payments, at least you have that under control. So this I would say that are kind of the four kind of alternatives that a foreign global company would have when they decide to start a business in Spain. Number one is the independent contractor. Number two, creation or incorporation of a subsidiary. Number three, registration of a foreign company to be an employing entity in Spain. And then number four, the use of an employer of record.
Yeah, that makes a lot of sense. So, there's a lot of different avenues you can go down to start, dipping your toe in the water or investing quite heavily in the market. Like you say, if it's going to be a shared service center, like you're going to hire a lot of people, then maybe you go full blast from the outset. I want to talk a bit about employer of record for a moment because the Spanish context of employer of record is somewhat different to some of the other countries, right? So could you perhaps explain a bit more about that?
Sure. Thanks. I mean, that's a great question, George. I mean, there's been a lot of discussion, in Spain about employers of records, and I'm sure there's been in other European countries and even some countries outside of Europe as well. We do have a concept on our Spanish legislation, which is a prohibition of employee leasing. What does it mean? Well, it means that you cannot hire an employee simply to second or place the employee at the disposal of an end user company. Unless, you are a temporary work agency, but you as a temporary work agency, you can only, let's say, second employees to an end user company for a fixed term period of time. And whenever there is some sort of business justification or business grounds for that. So essentially, the prohibition of employee leasing, would fall, into the activity of the employer of records. However, as we were saying before, the employers of record are guaranteeing some sort of compliance with the end user company because you are paying taxes, you are paying social security contributions, you are payrolling the staff. So you're not having the staff without any payroll. You're not having the staff as independent contractors being able to pay for their own salaries and social security contributions. So even though there is a little bit of a gray area in terms of how this prohibition of employee leasing could actually apply to an employer of record in Spain, and there's not a lot of case law about that. I mean, that's what I can say. But it's still it's a good recommendation in terms of compliance, particularly, if you don't want to go direct, if you don't want to set up a subsidiary company, and if you don't want to, incorporate into the cost of registering a foreign entity and getting into a new payroll company just for you. So the product that an employer of record provides for the clients, for the customers in Spain, it's a convenient way because at least you guarantee some sort of compliance on the most significant liability terms, which are social security contributions and tax withholdings. And in some cases, having this warranty of compliance with tax and social security would be, a much more preferred benefit as compared to the legal interpretation of, this prohibition, as we were saying before. Again, if you don't want to go direct, the alternative is to have an independent contractor, which in terms of liability, it might create a significant risk of misclassification. And it creates a lot of difficulties in negotiating any termination, because you have to negotiate not only termination payments, but also the cost of the social security contributions and income tax that have not been paid. And if you have someone who's been working for 5 or 6 years, it might be relatively significant. At least with the alternative of the employer of record, you minimize to a large extent this sort of liabilities. The employee is on the system, the employee is registered, the employee is payrolled in Spain, and it's being paid the salaries and benefits that are required by the Spanish legislation, and all the payments to the different authorities are being absolutely paid in a compliance way. So there is some sort of a gray area, as I know that there's in other countries as well. There's not a significant body of case law so far, but it is a convenient way to have this kind of a start out or the launching phase.
That's really, really interesting. So to play that back a little bit, there's not a huge amount of case law on this, but The key things are the tax and social security, and I think also probably the works councils and the collective bargaining agreements. Like they should all be covered under employer of record. At least a good employer of record will cover all of these things. Whereas if the alternative is a contractor, like none of these things are covered, that creates a much more significant exposure for the client if they're exploring different options in the country, right?
Absolutely correct. I mean, of course, there might be some cases where an independent contractor is really an independent contractor. I mean, you assign a project to someone who is based in Spain, living in Spain, and doing a project which is an isolated project, which there is no reporting to anyone in the company, which the contractor is not part of the organizational chart of the company. But that doesn't happen very frequently. I mean, in most of the cases, the contractor, even though he's based in Spain and there's no kind of any other member of the company who is also based in Spain. Sometimes the contractor has an email address from the company. The contractor has, is included in some sort of organizational chart, is being given kind of the laptop or the computer directly kind of by the contracting legal entity. So, I mean, there is some prospects that a misclassification case can be built in and can be successful before the court. And that's where kind of the alternative of the employer of record kind of is convenient because at least there will be not that scope of liabilities as an independent contractor have, which is that the contracting company is not paying the salaries and is not paying the social security contributions. And for instance, social security contributions is roughly speaking 38% of the base salary. There are some caps which would apply. And then income tax withholdings might be even up to 46, 47, 48%, depending on the region of Spain where you are based with. So, I mean, if you have an employee who is getting 100,000 euros, then the liability might be like, on top of 60 or 65,000 euros out of that only for one given year. If you multiply by the limitation period, which is 4 years, and then you add the kind of the termination payment on top of that, you might be easily into the region of 200,000 to 300,000 euros of liability, which with the employer of record, you definitely minimize that risk. And then you will only have to pay the termination payment, which will be due because the employee has been registered and payrolled in Spain. That's what I, wanted to mention in terms of that.
That's really interesting. So if you take those two alternatives, you've got the employer of record where you are paying the correct social contributions, employee income taxes. On the independent contractor side, you're not. So what you're saying is that, like, although there's not much case law on employer of record, there is on misclassifying employees as contractors. So you will typically expect to back pay all of the contributions that you should have made up to a period of 4 years. Is that right?
Yeah, absolutely correct. You explained that very well, George. That's absolutely the case.
Yeah, that's really interesting and definitely an eye opener. Let me switch lanes a little bit now. You've consulted a lot on labor law, pension incentives, and things of that nature. What does a competitive employee package look like nowadays in 2024?
Well, that's a very interesting question. I mean, as a preliminary point, I mean, I would like to mention that we do have a system of collective agreements. I mean, we talked about before the kind of the works councils and the unions at the beginning of the podcast session, but we do have collective agreements that are compulsory or mandatory. That means that I mean, every company must apply a collective agreement, and the collective agreement depends on the area of business that every company is in. So, for instance, if you are on the pharmaceutical sector, then you would have to apply the chemical collective agreement or the distribution of pharmaceutical products collective agreement. I mean, if you're manufacturing cars, then you would have the steel collective agreement. And if you are on the consulting world, then you will have to apply the consulting collective agreement. So collective agreements are compulsory and it applies irrespective on whether the employer is a member of the employers federation who signed the agreement. And it applies also irrespective on whether the employees of the company are actually affiliated to a union or belong to any union. So even if you're not, I mean, even if the employer is not a member of the federation signing the collective agreement, and even if the employees are not unionized or affiliated to any union, the company must apply a collective agreement. Because of this kind of compulsory nature of the collective agreements, they provide for kind of minimal basic protection. So they provide for minimum wages for each kind of job title or job grade, and they provide for kind of minimum benefits. So these are to be respected and to be observed by every company within same kind of business practice. But most of the companies will provide for what we call enhanced voluntary or contractual benefits. And these kind of additional enhanced benefits, they really, really change from company to company. So it's hard to say that there is a one size fits all approach. Here it's more on the contrary. There is more and no one size fits all approach. And every company will decide, particularly any global company will decide what that means, how competitive they want to be. They would have done kind of the benchmarks, and they probably kind of have hired a consulting firm to say, okay, well, this is a competitive package in the way it would look like. I mean, examples of benefits that are kind of easily implemented in Spain, and that when I discuss with my clients when they launch a business in Spain, well, it is typical to provide for health insurance, even though, I mean, in Spain, we have a relatively good public health insurance, which might also be one of the reasons why people would like to live in Spain. As we said at the very beginning of the session, but also employees very much value the possibility for them and also to the family members to be enrolled on a private health plan. Life and disability benefits are also kind of well viewed. So I always recommend to look into that and see whether, life and accident insurance or life and disability insurance can feed into kind of a cost exercise that every company will be doing. And we have the issue of the pensions. So pensions, of course, I'm talking not the public pensions, but the supplementary pensions or private pension schemes are again very well valued by employees, but there is some cost of administration of a company pension plan that if you have only a relatively small population in Spain, it might not be worth it just doing the effort of setting up a company pension plan if you have, let's say, less than 10 employees. Even though in the market, kind of, there are some alternatives that you can go into a multi-employer pension plan, which will facilitate the setting up process. But some of the companies, when they have a relatively small population in Spain, they prefer to save the cost of the administration and the setting up of the plan, and they just simply prefer to increase the base salary or even to make a cash allowance to the employees. There is another benefit that is well viewed, which is the company car. But I mean, the trend is just not to give company cars any longer to employees, particularly for those who are working from home, because they usually don't need the company car to go from, the office to, a client visit. And now everything, it's kind of more on the virtual world. But it is again, particularly, for Spanish-based employees who've been working for other companies is a well-viewed benefit. And then there is, of course, anything that comes with variable compensation. So, bonus scheme, it's very well known and, particularly on a global company, everyone will expect when, he or she is hired by the company to be eligible to an annual an annual bonus plan. There's also the possibility to give kind of employee equity to the employees. And we don't have a large tradition and a huge tradition in terms of employee share plans in Spain, but global companies have decided to implement that in a number of ways. And now, particularly in the tech sector or in the engineer sector, it is kind of an expectation of the employees that they might be given or they might be granted some sort of employee equity. And it's relatively easier and straightforward to be implemented in Spain. If you have a global share plan, let's say in the UK or in the US, and then you want to make your Spanish-based employees a participant to the share plan, it is relatively easy and straightforward to implement.
Yeah, that's really interesting. I think when it comes to benefits that we offer for our employees and for our clients, I think the key thing that we often think about is flexibility. Sometimes we have really well-established companies who come to us and say, "Look, I want to hire, a handful of people in Spain," and they might really care about some of those first things you mentioned, like health and disability and pensions. Like we've just rolled out a new pension scheme that allows people to go, into quite high percentage points with pensions. But then more of the kind of the younger startup companies, they're often giving more equity, more of a percentage of the business to these employees. So, but then they're holding back a little bit, perhaps on like the
Mhm.
pensions. And certainly, obviously, we don't see many people offering company cars. I certainly don't need a company car. My commute is about 10 meters, so I don't need don't need a car for that. But it's really interesting. I think flexibility is the key thing that we often
Yeah.
like try to bring forward.
And it is also, even in terms of flexibility, it's also possible to implement what we call kind of a cafeteria plan, which is, I mean, the employee can pick up and choose depending kind of on the life cycle of the employee. Like if you're young, you might not be very much kind of concerned about pensions, but you might view, I mean, the share plans much more in detail. And when you are kind of getting kind of old, I mean, pensions might be a much more significant piece in terms of the benefit programs and the flexibility you have. I mean, of course, running a cafeteria or what we call a flex comp plan, it also creates kind of some costs. And again, it will depend on how many employees, I mean, you would employ in Spain in terms of the setting up process and in terms of the kind of fees associated with the plan. Because of course there has to be some sort of election processes and some sort of, negotiations with the different providers. So, it's good to see how many employees do you have right now? What is the cost and the benefits associated with this? And, is it really worth just doing into a first stage, or shall we better wait until, let's say, we have 25 employees or we have 50 employees in Spain in order to launch kind of this FlexCom plan? Because that will give kind of the cost. It will be kind of a little bit much more admissible to make the cost because you have much more larger population. So again, there's not a one size fits all. But the good thing is that you can be creative and you can be flexible, and then you can adapt to whatever the philosophy of each corporation, of each company is, and the people that you really want to attract.
Makes total sense. Now, Juan, one other thing I wanted to ask about. So you've worked extensively on not just in Spain and on Spanish employment law, but also in Latin America and with Latin American companies. I wanted to get your perspective on some of the most critical differences between labor laws in the two different regions. How does EU and Spanish law compare to, let's say, law in Colombia, Mexico, places like that?
Mhm. Well, I mean, as you well said, I mean, I've worked in a number of kind of projects in South America. I mean, Spanish companies, they really, I mean, have seen South America as the main investment point. I mean, they've invested in the UK, they've invested in the US, but generally every big company in Spain, they have significant businesses in different countries in South America because, of course, we share the language, except for Brazil, but we share kind of the culture and there's been kind of the typical trend from Spain in terms of keeping the foreign investments and making the foreign investments work. So on the legal side, particularly on the employment legal side of the labor and employment legal landscape, Latin America is not that different from Spain. I mean, there's been even a trend for some Latin American countries to kind of to copy and paste some of the legislations that we've been enacting. Like we've been much more restrictive in terms of the use of fixed term employees we were in the past because it was kind of relatively flexible. And I know that there's quite a few of South American and Latin American countries who have implemented kind of very, very similar legislations or pieces of legislation to prevent the kind of the extensive use of fixed term work. So it is a very similar environment. So we feel confident and comfortable because it's not that much different. There is a little bit more protection in South America, even though as compared to Spain. So, and there's a little bit more of kind of uncertainty and some of the issues. But I'm talking generally about the region, right? I'm not talking about specifically one country or another. But the legislation is similar to the one in Spain, but it is applied with a much more enhanced employee protection as it is in Spain. Well, I mean, I can give you a quick example. Like there was on a project very recently in Ecuador for a case which was a clear gross misconduct of an employee there. Even if it was a relatively clear fraud case of gross misconduct, you have to apply for a specific authorization to dismiss the employee. Prior to dismissing the employee, you can put the employee on garden leave, but you cannot dismiss the employee unless there is a public authority, which it was the labor inspector, authorize you to do that. And if there was no authorization, you can do that, and then you have a risk of, paying back pay salaries for a number of years. So liabilities might be very, very significant. So even on a gross misconduct case, you can even find kind of difficulties because you cannot take the decision and leave the final decision to the court to decide. You really have to go to an authority before you actually take and implement the decision. So that's kind of the concept of the enhanced employee protection that I was mentioning. There is, however, one trend, which is still Spain and European Union is treating that a little bit differently, which is there is a general trend all over the Latin American countries, which is they're trying to prohibit subcontracting, even if the subcontracting is within the core business of the company. So, for instance, like that started in Mexico, but has been followed in Peru, that has been followed in Colombia. There's also some trends in Brazil in terms of, okay, you're a company, you do that, you cannot outsource, you cannot subcontract, areas where belong to the core business of the company. And that's a trend that we still don't have that in Spain. In Europe generally, and in Spain in particular, we're dealing with this more in terms of, okay, well, if you subcontract part of the core business, then the employees that are part of the subcontracting entity would have to be paid the same as your employees, but that will not fall into a full prohibition. It will just simply be like a salary kind of equitable or equity scheme, which says, okay, you subcontract part of your core business, you will have to pay the employees of the subcontracting entity the same. But in South America, it's more you are prohibited into that. Some of the reasons behind that is because, like in Mexico, you have to pay for the a little bit of a profit sharing plan, and you don't want some profits to be out of the company because that will reduce the pot to be distributed into the all employees of the company. And that might be one of the reasons behind kind of getting more aggressive into the prohibition of subcontracting or contracting out whenever this is part of the core activity. And also in some countries, the definition of the core activity has been kind of very extensively interpreted by the regulatory body. So it's everything is kind of part of the core business of the company. So this is what I would kind of say, that again, it's pretty similar to Spain, but there's much more of enhanced employee protection. And particularly, there is this concept of prohibition of subcontracting or prohibition of contracting out, that it's kind of being applied very extensively all over the Latin American countries.
Yeah, that's really interesting. When you first mentioned that, I was thinking, maybe this is like a corporate tax thing. Maybe they don't want the different subcontractors to then be declaring different levels of corporation tax. But actually, you mentioned it might be more around profit sharing, and actually, it's more of an employee protection that's being put in place.
Correct. Absolutely correct. At least this is the case definitely in Mexico because they have the concept which is called PTU, which is a profit sharing that you need to distribute by the end of every year. Yeah,
Yes,
that's absolutely the case.
cool. I want to move on to something else now, Juan. So you've got a lot of experience advising in corporate transactions, and I'm curious to get your take on what are the most common legal challenges or pitfalls in terms of labor implications during, let's say, cross-border mergers, maybe between European and Latin American entities.
Mhm. Well, I mean, in terms of kind of mergers and acquisitions and transactions in general, or the employment aspects or influence or also, transactions and deals, Spain is a 2P country, like transfer of undertaking. So we have an automatic transfer of employment whenever there is kind of a business that it's acquired by another company. So if there's a company acquiring the assets of the company and those assets are significant, then there is an automatic transfer of employment. And then the buyer would have to safeguard not only the employment of the individuals, but also the terms and conditions of the employment. This is generally the case all over Latin America as well, by the way. So there might be kind of a few exceptions, particularly in Central America, but from Mexico, excluding again, 2 or 3 countries in South America, and then on the South everyone is kind of a 2P, what we call a 2P protection country. So in the event of a deal, there will be an automatic transfer of employees from one company to another. That's in terms of kind of the legal concepts. Then what are kind of the typical issues that are under discussion or that might even be disputed? Well, number one is the definition of the perimeter of the transaction. So because we have an automatic transfer concept, it is not uncommon that there might be some employees who are working at the seller level, at the seller side, and who are working partially to the business that is being acquired by a third company, but also they are significantly working for the business that is not acquired and that remains and is retained by the seller. So there is kind of some sort of discussion as to, when you are an employee who are working predominantly for the business to be transferred. We usually and we typically interpret that as if you work more than 50%, you have to move and you have to transfer. If you work less than 50%, you will have to remain and retain either seller level side. But of course, you have to analyze that on a case by case basis because, again, this is not kind of a general rule that can apply in every single situation. So the definition of who are the employees who will automatically transfer to the buyer is a very kind of well disputed area, particularly as I said, because in most of the cases, employees are working from one or from two different divisions of the company. Then there's another very, very important one, which is the harmonization of benefits. So we talked about how to set up new benefits, right? So here we're talking about a company who buys, the business of another company, a company which might be an existing company having their own terms and conditions and their own benefits. And then you acquire, let's say, 50 employees of another company who are inheriting, completely different benefits. So there has to be some sort of harmonization process, even though what the legislation say is that you have to apply exactly the same terms and conditions, or you are entitled to the same terms and conditions. Sometimes this is not even possible. Let's figure it out that you have an employee share plan, at your previous company, and then the company acquiring that it's a fund that does not offer this because it's not kind of a quoting company, and it's a private fund. So there has to be some sort of work on the harmonization level. That might also be kind of a disputed area whenever there's an acquisition. And at the end, eventually, you would minimize the problems by offering benefits that are in global terms higher than those who the employees used to benefit at their previous company. But of course, it's easy to say, but then it's much harder to implement when you put into comparison. You have an Excel sheet. Okay, benefits at the seller side, benefits at the buyer side, and then you examine all of that. So that is, I would say, these are kind of the two essential issues that might be subject to discussion, to negotiation in between seller and buyer, which are, number one, who are the employees who will eventually be automatically transferred to the buyer, and then number two, how to harmonize benefits on the assumption that not all the benefits that the employees were benefiting when working for the seller will be, will continue at the buyer side.
Yeah, that makes total sense. Juan, I know you've got to leave in like 5 minutes, and there's one question I really wanted to get your perspective on before we wrap up. We talked a little bit about managing remote international teams, especially as you mentioned, like people come to Spain often because of the lifestyle, the culture. Remote working is really kind of taking off there. So I really wanted to get your perspective on, or get your advice really on, for companies that were managing employees across different jurisdictions. How should they think about the rise of remote work and Spain in particular for that?
Well, in terms of kind of managing kind of international remote employees, and we've seen that, and we've seen companies that have been very, very well organized, companies that they didn't do anything and they just realized kind of a few years later that they have an employee working remotely in Spain and no one had a clue about that. So the first recommendation is to track, or to try to track as much as you can, where your employees are. So it is different to say that someone, have an employee in the UK who will be working remotely in Spain, for 2 months in the summertime. But it's different to have someone who's been working significantly for 4 years in a row from their home in Spain. So the first recommendation is track where your employees are. And the reason for this is because you need to, you have some sort of obligations in terms of payroll, in terms of paying taxes, and in terms of paying social security contributions that you really need to track down. So the first thing is know where your employees are. I know that, sounds very obvious, but not every company has done this exercise to that large level of detail. So first, track where your employees are. Number two, once you have this map about where your employees are, try to see whether you would like to implement a policy. Some companies, they implement a policy which says, okay, you can work internationally, remotely, but there's a limit of 90 days, which is the typical limit for immigration laws, for taxes, and also for social security. So if you work internationally for 90 days, you're usually okay. But if it extends more than or beyond the 90-day period, it can get complicated. Not necessarily within Europe, but outside of Europe, it will definitely be. So it's good to have a policy, and it's good to see on the policy what you want to do. Do you want to allow everyone, and then you will have to track compliance in a much more detail, or you want to say, okay, you can do that, but to a certain level of extent, so that the company will not be involved in any liability. And then number three, think carefully where you want your employees to be, working remotely. Because, of course, some countries are easier in terms of just doing remote work. Some of them are more difficult. Some of them are more restrictive. Some of them, they require local registration from day one. Some of them, they might have a concept of permanent establishment from a tax level that might be kind of quite significant once someone works there, and is being set up there. So, I would say that think carefully as well, if you want to allow that in any country in the world, or if you are going to allow only to the, countries that the company has some sort of level of control. So number one, track where your employees are, which again, sounds very obvious, but it is not always the case. Number two, decide if you want to have a policy. And if you want to have a policy, implement the policy. And then number three, think about if you want to allow the employees to work in any single country, or only kind of on the countries where the company has some sort of level of control.
Fantastic. There's a really helpful takeaways. Juan, thank you so much for being on the podcast today. Let me just tell you a couple of my key takeaways, and then you can tell me if I've missed anything, and then I'll promise I'll let you go. So a few of the things we've talked about today are, when you're employing in Spain, you've got to be wary of terminations. It can be much more complex there than some other countries, like at-will countries like the States. Be wary of works councils, because that applies to every different industry, whether it's in the contract or not. You're going to be, you have to apply those. When you're going through M&A transactions, the to-be process is going to apply. That's where you'll have to do things like harmonized benefits and contractual terms with employees. And it's often easier said than done when you've got one set of employees having one set of benefits and then a new set of employees tapping into that. Another thing is classification. If you get classification wrong with employees, that can be very costly, up to 4 years of back paying taxes and employer costs. And then the fifth one was about remote employees. I think my key thing is there: be deliberate about where your employees are, what your policies are, and where you can and can't allow people to be for longer periods. Anything else you would add on top of that?
Well, that's a great summary, George. You're fully trained now on doing businesses in Spain in terms of labor and employment laws. So,
Thank
yeah, I
you so
think
much,
that was a
Juan.
very, very accurate summary.
Glad to hear it. I was paying attention. There's a lot to be said here. I could spend another 2 hours probably speaking with you, but I know you have to go. Juan, thank you so much for being on the podcast today. It's been my absolute pleasure.
Yeah, also been my pleasure and my honor again, George. So thanks again, and thanks to everyone who will be kind of viewing this, listening to the podcast. Thank you.
Awesome. Thank you so much.